Good afternoon. My name is Reverend Dr. William J. Barber II, President of the North Carolina NAACP, and we're here today to raise our continuing concerns over the redistricting plans that were, have, and are being crafted by our General Assembly. It is important for us to note that this entire problem started when extremists under the leadership of Phil Berger and Tom Tillis passed the worst unconstitutional redistricting plans that we had seen in North Carolina since the 19th century. The level of what is called stacking, packing, and bleaching was extreme. And we continue to stand upon that, as many scholars have as well. This apartheid redistricting created a situation of unconstitutional effect among black and minority voters and produced a situation where persons were elected more by how the districts were drawn in an unconstitutional way rather than the vote of the people. This should have never occurred. It should never have been the case. We should have never seen this level of stacking and packing and bleaching of black and minority voters for political advantage. We've had a case now that has made its way to the state Supreme Court, and it was reviewed by the U.S. Supreme Court. The justices, and most people never really pick this up before we even get to the current case, the justices said about the ruling of our state Supreme Court on our case, the NAACP's case, that the courts nor the leadership of the legislature asked the right questions about race. This is a very important fact, and it's very historical, that the Roberts Court, when they reviewed our concerns in our case about how the state districts, legislative districts were drawn, that court said that our state Supreme Court nor the legislature had asked the right questions about race. Sent it back to our state court and asked them to ask the right questions about race and to properly apply the law. The state court reviewed and refused to ask the right questions about race, and once again, in a split decision, decided not to overturn what it had done, even though the U.S. Supreme Court says you have not asked the right questions about race. We then asked them to reconsider, and they denied it, even with the U.S. Supreme Court saying you did not ask the right questions about race. Because that is not just a question of how many black legislators you have. Did you just increase the number of black legislators? The question becomes, did you do that in a way that violates the fundamental principles of the Voting Rights Act and stacks and bleaches and packs black voters in a way to undermine the ability of black minority voters to join with other white voters and elect candidates of their choice? So now, our lawyers in the area are talking about how we're going to handle this refusal of the state Supreme Court to even listen to the advice of the U.S. Supreme Court. And media should know, if we are applauding an action of the U.S. Supreme Court under its current leadership, that's a pretty big deal. That the Roberts Court that overturned the Voting Rights Act, Section 4, that court that we have deep issues with, would in our case say to our state Supreme Court, you didn't ask the right legal questions about race. Now, In the federal case, and by the way, the federal case that just forced the legislature to redraw they came forth. That wasn't our case. Certainly the facts that were put in the public square probably helped that, but that was not our case. It was based on the congressional districts. And the courts ruled, and we encourage the media to read the opinion of the judges, both the first judge and the three-panel judge. It said, three-panel court. It said that the congressional districts were race-based. And we here today, we applauded the recent decision by the U.S. Supreme Court to deny the General Assembly's motion to stay the federal court's order to redraw its congressional district. And we have argued, and the federal court has agreed, that the General Assembly, when it did its 2011 redistricting of the congressional districts map, they were racial gerrymanders. We have argued, and the federal courts have agreed, that the Voting Rights Act, the 14th and the 15th Amendments to the U.S. Constitution were violated by our General Assembly's actions and by this racial gerrymandering and apartheid redistricting. The federal court's opinion have affirmed our arguments, and we believe that the opinions that have been rendered in this federal case applies equally applies to the North Carolina NAACP's pending challenge to the racially gerrymandered state district. And we believe we have to move on this case, and we need the courts to move on that case as well. However, and then I want to turn this over to Attorney Joyner. While we applaud the U.S. Supreme Court's decision to deny the stay, in essence to say, we're not going to have this held up, we are voicing today serious reservations about the newly drawn districts put together in 2 short days of hearings last week. And by the way, even in those hearings, they were disingenuous because we find out over the weekend they're at 10 o'clock in the day, which many working people, minorities, can't attend, and there were no maps there presented for anyone to review. So what were they really having a hearing on? We expect in our democracy officials who have taken the oath to uphold the Constitution of the United States would respect the fundamental principles of the democracy and not try to stack the deck against people of color who were denied the right to vote all the way until 1965 in North Carolina. So we are in the middle of a serious review, and we have some serious reservations about these maps as well. It should be deeply concerning to every North Carolinian, that we have had 2 elections already held in this state for state legislators and the United States Congress that have used districts that were unconstitutionally constituted. Please hear that. That's right. That you have had elections held twice in unconstitutional districts, and these persons that were elected in these unconstitutional state, we believe, and federal districts have been at the forefront of rolling back our constitutional rights. That's right. I mean, every North Carolinian ought to be concerned about that. Now, we had hoped that the General Assembly would recognize the legal fallacy of its attempt to use race in an illegal manner to construct political districts. And one of our concerns that we are reviewing heavily now about these latest maps is that even if it's described as partisan districts, it can still be a cover and a design for the purpose of disenfranchising racial minorities, which is why, members of the media, this is not the NAACP's opinion. The judge, I believe Judge Cochran, I believe his name, but the judge in this case said that partisan gerrymandering is not good for our democracy. That's not our opinion. In the opinion that he rendered, he said that partisan gerrymandering is not good for our democracy. So even though we have now some new maps and that now have to go before the courts, we're having some serious reservations about where we are. And think about where we are, lastly. We've had this stacking and packing. The districts they did in 2011, I think the numbers were something like 51% of black voters were stacked and packed into 27 out of 120 House seat districts, and 49.7%, something like that, in 19 out of 50 Senate seats. And it produced in this state supermajorities of one particular party, even though the overall electorate, the overall vote was not in the majority of that particular party. And it also took us from a 7-6 split party rise into a 10-2, right? 10-2, 10-3. Now, our concern, however, is not the party stuff. We are concerned that this legislature has had a deep disdain and has expressed it in policy for the principles of the 14th and 15th Amendments of the Constitution and the Voting Rights Act. Equal protection under the law and not denying or abridging the right to vote. They have abused the Voting Rights Act 50 years after its signing. And we believe it is a great travesty in our democracy, and particularly in a southern state, to continue to engage in producing unconstitutional, constituted legislative districts, simply because evidently some folk believe they can't win in the public square, so they cheat in the legislative back room.
Thank you. I'm Herb Joyner, and I'm serving as legal counsel to the NAACP in these cases. And there is a lot going on with these cases. First of all, we are going to ask that the federal court, the 3-judge panel, to reject the newly enacted legislative proposals, and for the court to draw its own plan. We are suspicious of anything that this legislative body does. And we are certainly concerned about their motivation. We've had 2 illegally held elections already. So we're going to ask the federal court to take over the drawing of the lines. And then we are going to join the effort to get all of these cases before the U.S. Supreme Court, because we are in a legislative crisis right now. And the people of North Carolina need to know as soon as possible what the final say is on the law as it applies to the drafting of not only congressional districts, but more importantly right now, legislative districts. That is a claim that we filed in the state court. The partisan North Carolina Supreme Court upheld that illegal construction, and we need to get that to the U.S. Supreme Court, and our motion to seek certiorari in that case will be filed shortly. But we want to get all of these cases to the Supreme Court so that the Supreme Court can have a final say on what the law is in North Carolina. We are elevated in our hope and our optimism by the Supreme Court's decision not to grant a stay. And the fact that no justices on the court issued a dissenting opinion gives us real hope that the Supreme Court is tired of these cases coming from North Carolina that are constructed for the sole purpose of undermining the voting strength of African Americans and other racial minorities here in the state. So we're moving forward to continue our challenge, and we will see, and we will ask the court to expedite a decision in these cases because we need a final word. And we need that final word from the Supreme Court, and we need it now. So we'll open any questions.
Yes, ma'am.
Dr. Joyner. Question for you. Are you planning to ask to expedite the Covington case as well in federal court, or would the plan be just to try to advance that to the Supreme Court?
The federal court decision is going to be appealed by the state. In fact, they've already indicated that they are going to appeal it. We are appealing our state court case to the Supreme Court, and we're going to be asking them to combine those cases for consideration. Now, there's still an untried case in federal court dealing with the state legislators. Right. And we're going to, to the extent that we can, try to influence a quick decision in that case so that we can all join them together at the Supreme Court as soon as possible.
Yes, sir.
Can you talk a little more specifically about what the legal argument's going to be to throw out the map that was created last week?
Well, the legal argument basically is that a partisan gerrymander is in effect a racial gerrymander. When you look at the fact that they're trying to exclude Democrats from office, where roughly 49% of the Democratic Party is made up of African Americans, when you start discriminating or gerrymandering based on partisanship, you also have the effect of discriminating and gerrymandering against racial minorities here in the state. And in some instances, they become inseparable when you look at what the numbers are and how the configurations are. So that's the central argument that we make, and that will also deal with this notion of the effects, the impact on the racial minorities and the 14th and 15th Amendment violation.
It's important for particularly as you talk to the public and media to, if you look at all this stuff in a vacuum, like a contemporary vacuum, you can kind of miss the logic because most of us try not to think like this. And what I mean by that is, the old way it was done was, well, we're going to put a literacy test, for instance, on voting. Not against black people. And on the face, it looks like it's not against black people. But then when you know the statistics of the number of black people that were illiterate at that time, then in fact it becomes a race, even though you never used the race word. So one of the arguments, as he said, is that partisanism, and that's why the judge said, even doing he said that in the opinion, is not good for our democracy because it can be a cover and still have a disparate impact on minorities and African Americans. The last thing is we should listen very carefully to the legislators. They criticized the courts for finding their actions unconstitutional because they said it would cause disarray in the election. I mean, listen to the logic of what they said. In other words, if we do something that's unconstitutional and we can mount enough challenges and enough briefs and enough delay to get it close to the election and we get caught, that's all right. We're too close now to do anything about it. That's the logic. And we should be appalled in this state that we've had two bodies elected twice who have voted on everything from voting rights to education to living wages to LGBTQ issues to the environment to health care. And now we're finding out what we always argued, that the bodies that voted on our Constitution were constituted unconstitutionally. I mean, it's... Yeah.
And then you have to also remember now, while the federal court case has articulated a concern about two past illegal elections drawn from illegally constructed districts, we're in the process now of having 3 elections at the state level, with state house members and state senators that will now go through this process on March 15th or beginning March 3rd. And that is illegal because the same logic the same justification that the General Assembly used to draw the congressional districts were the exact same thing that they used to draw the legislative districts. So we need a decision as soon as possible on the legislative districts so that those races, we won't have a third rerun of an illegal election here in this state.
Yes, sir. Any other?
Procedurally, would that also just go to Justice Roberts himself? Do you know procedurally how that would happen? If you how do you combine all those cases at that level of?
Eventually, it will end up with Chief Justice Roberts. Right now, we still have to go through federal court to have them to exhaust their process, unless there is some mechanism where the Supreme Court decides to bring those cases up. I doubt seriously if we're going to be able to convince them to do that. So it's still going to have to go through the federal court, and what we are pushing in the federal court is a quick determination from them so that we can get these cases up to the U.S. Supreme Court.
Now, lastly, and hear this, it's important, because their line is too close, it's causing chaos. It's kind of it's a diversion tactic. Y'all are causing chaos because you filed these suits. And if you hadn't filed them, we wouldn't have been found unconstitutional. And now it's too close. The problem is they did not have to do this. They could have drawn the maps using the law constitutionally. They did not have to draw maps that we have not seen since the 19th century in its attempt to undermine the power and the presence of the minority vote. They didn't have to do that. And the state Supreme Court could have asked the right questions about race. And when the U.S. Supreme Court sent it back and said you didn't ask the right questions about race, they could have said okay and asked the right questions about race, and they still didn't. So if there's been any delay, if there's any chaos, if there's any trouble and confusion, it has been caused by legislators who have confused their role, who thought that once they put their hand on the Bible and swore to uphold the Constitution, that meant they could then violate the Constitution. That's where the problem is. That's the problem. Yes, sir.
Do you know of any recent examples, perhaps in other states, where judges have done like you asked and drawn the maps themselves instead of kicking it back to the legislature to fix it?
You asked me that, and yeah, there's been a recent Virginia. The judges in Virginia did just that in the decision where the court determined that the Virginia lines were illegally drawn, and the state legislature did not present lines that were acceptable to the court, and the court drew its own lines. So that's within the power of the court to do, and we'll call upon them to do that in this case, in the interest of fairness, in the interest of complying not only with the state constitution, but also the federal constitution and the Voting Rights Act.
Yes, sir.
So I hear you criticize, I mean, are you essentially saying that the legislature is using political affiliation as a proxy for race? Am I hearing you right to say that?
Well, what we're saying is the whole problem started because they use race not as a proxy for race, but they use race.
Right.
And they create it. And when you look at these maps, we have deep suspicion. I think the lawyers, we're saying the federal, because you can, in fact, use partisanism as a cover for another racial agenda. Listen, what we've got here.
You're saying that's what you think happened? You think that's what happened? They used partisan politics to determine a racially based makeup of a map.
The effect of what happened is to make partisanism the proxy for race.
Right. And so remember what the historic piece of what we're dealing with is the continuation of certain politicians to push the white Southern agenda and to create the solid South. That's where this is coming. You don't look at that, you admit, where there were all these kinds of decisions post-1968, Kevin Phillips, Richard Nixon, perfected later on by Ronald Reagan and others to lock up the South. They've stood, the same people here are the folk that stand against the Voting Rights Act. They're the same people that have written all of our voter suppression laws that scholars around the country say are the worst voter suppression laws anywhere in the country post-Shelby. And then thirdly, we know where we are. We are in a time in the South right now where just 30% more of African Americans unregistered, if they were registered, and they join with Latinos and white, it breaks open the demographics. The political landscape of the South is fundamentally under reconstruction. And all of these things, we're clear, they are an attempt to hold on, to undermine the public will, to disempower this new demographic of black, brown, and white voters. That's what's going on. And that is why even in the first state maps that they drew, they said things like, well, we gave you an extra black senator but they drew the maps in a way that may give an extra black senator, but you use an invalid way, unconstitutional way of stacking and packing black voters, and then you undermine the power of the black vote in other districts, which may not be about electing a black person, but electing a person of your choice and building the kind of coalitions that can do that. We've not seen this since the end of the first Reconstruction. We've seen this kind of thing, and we've seen it since the implementation of the Southern strategy. And the Southern strategy is breaking because of the new demographics, and these attempts are attempts to hold on to it. And it's unfair, it's unconstitutional, and it's un-American. Thank you all so much.